I'm surprised that she was able to get 122 pages worth of words since she appears to be completely incompetent with regard to her knowledge with firearms law.
We are the Armed Attorneys. Today we're talking about a massive piece of gun control that was recently upheld as constitutional. Now, this has a large capacity magazine ban component to it, along with requiring a permit just to purchase a firearm. Now, we got to dive into the details of this, but before we begin, share your support for the Second Amendment by hitting that like button. And today's video is brought to you by our friends over at Sonoran Desert Institute. Check them out for online gunsmithing and so much more. Take your hobby to the next level, make a career out of it, even at sdi.edu/armed-attorneys. And our next sponsor is Gunspot. Gunspot.com is a new and incredible website improving the Second Amendment listing and auction space, connecting buyers and sellers in a way that they will both love. Guns, ammo, accessories, and more are for sale by dealers and individuals all over the country. Buyers get great deals and never pay out-of-state sales tax or any hidden fees like some other auction sites. But there's more. Gunspot Academy gives the 2A community a new blog space for entertainment and news. This space is great for 2A content, so check them out at gunspot.com.
I'm going to go check them out.
So today we're talking about Oregon Ballot Measure 114. Now, this passed November 8th, 2022. It is effectively up until July the 15th, 2023, effectively has been prohibited from going into effect, but that all changed. And what's going on?
This is one of the West Coast's numerous gun bans, specifically banning high capacity magazines, which we know how much I hate that term, high capacity magazines, as well as requiring a permit to purchase a firearm. So I know most people are familiar with permits to carry firearms. This is a permit just to even purchase a firearm. You have to have a firearm safety code. So they're impacting your direct ability to possess a firearm. Also, it's creating a state registry of people who own firearms. Congress is not allowed to create a registry. I guess a state can create a registry until the courts get around to declaring it unconstitutional.
So in this context, when the state of Oregon uses the term high capacity magazine, they mean a magazine that's capable of accepting more than 10 cartridges of ammunition. So, I mean, we know that that's pretty limited.
Oh, yeah. Well, also, what I want to point out is this ballot measure passed by less than 1 percentage point. 50.7, some places say 50.6 to what, 49.3, 49.4. And this really does show one of the failings of democracy in that less than 1% of Oregon people can strip away the Second Amendment rights of half of the state. It's ridiculous that we allow ourselves to have our constitutional rights subjected to this kind of voter approval.
Yeah, no, I mean, that's why we live in a constitutional republic. We don't have, three wolves and a sheep voting for what's for dinner. That's effectively what this is.
I know. So every time a politician uses the word democracy, it makes me cringe so bad because we are not a straight democracy, and God help us if we were.
Yeah. So we're talking about U.S. District Court Judge Karen Emmegert, and she wrote a 122-page opinion. Now, she is a Trump appointee, but effectively, she found the measure constitutional. And we got to talk about her arguments a little bit because we are going to see an appeal to the Ninth Circuit Court of Appeals on this. And let's talk about the first kind of point that she made overall with regard to, if we don't do it, it's completely unintentional. Every time we are saying large capacity magazine, if we're not doing air quotes, believe us, we totally agree with you. We're doing air quotes, but she says that restrictions on large capacity magazines do not violate the Second Amendment. That's kind of our first overall.
Well, and she's got 2 points here, both of which are ridiculous points. Number one is that she believes, first of all, magazines can be regulated because they are not actually firearms, but they are accoutrement of firearms. That basically, and she attempts to actually use history to try to support her arguments by saying that today's magazines are akin to colonial times cartridge boxes, and that cartridge boxes throughout the literature were referred to as firearm accoutrement. therefore not firearms themselves, and therefore they can be regulated on that basis alone.
Yeah, and I think this is always a good telltale sign for folks if y'all are, wanting to read legal opinions, and we'll have that linked in the description down below. A good way of kind of judging whether something is if meritorious when you see a lot of if then kind of analysis by a judge. Well, even if this doesn't apply, then we'll do this, and if that doesn't apply, then we'll do this. We know that they're not on solid legal grounds because they know a higher court of appeals is going to come in behind them, and if they eliminate that first provision, well, then they have to evaluate this second backup and third backup. And she does this with large capacity magazines because the next thing she says, okay, well, this is not covered by the Second Amendment, but let's say it is, it's not in common use.
Which is absurd. I mean, I don't know if this woman's ever handled a gun in her life. To say that a magazine, especially when she writes in the opinion that magazines that hold more than 10 rounds are not commonly used for self-defense purposes. I mean, my God, every single handgun I own, except for my 1911s, hold over 10 rounds, have magazines that hold over 10 rounds. And so her statement is just, it's not borne out by reality. And this is the kind of delusions that a lot of these anti-guns, even anti-gunners that are appointed by Donald Trump, are under.
Yeah. Now our fallback from here is, okay, let's say, they're not covered by the Second Amendment. But if they are covered by the Second Amendment, they're not covered common use. But if they are in common use, then they are dangerous and unusual. And that's a standard we haven't seen since Heller.
Anybody who is familiar with firearms knows that they are not dangerous. I mean, a magazine in itself has no, if she's going to claim they're accoutrement,
right,
then they pose no danger whatsoever,
right,
until they're actually engaged with a firearm. And so the number of rounds that they hold, if these legislatures really want to go after people carrying too many rounds, then they need to ban the pocket. So basically they should pass a law that says if you're carrying a gun, you're not allowed to wear any clothing that has a pocket.
Yeah, talk to my wife. None of her dresses seem to have pockets. And then the last argument, okay, even if these aren't dangerous and unusual, that we get to the accoutrement argument, that they are not. We finally get to the New York State Rifle and Pistol Association v. Bruen, a standard by which we judge Second Amendment infringements. And they say, even if, we fail all the way down here, they are in line with regulating based on the text of the Second Amendment, as informed by history and tradition. And that's where we get to the accoutrement argument. Now, that was kind of the first big component of ballot measure 114. The second part had to do with requiring a permit just to purchase a firearm. And here she said that permitting provisions don't violate the Second Amendment under a shall issue scheme. And I think she's conflating carrying and purchasing.
Yeah, this judge, I'm surprised that she was able to get 122 pages worth of words, since she appears to be completely incompetent with regard to her knowledge with firearms law. And presumably she was presented with this information because it was a week-long trial. So I'm assuming that the plaintiffs did their job and tried to educate her on the matter. But this judge clearly is uneducatable when it comes to the practical aspects of firearms and firearms ownership. And so specifically, I think she said that the permitting scheme was not ripe for review yet, but that whenever it does, that the Second Amendment, the states are allowed to decide who can possess firearms, which of course is ridiculous, because she is taking a broad, generalized approach rather than the specific approach that has been, I guess, tacitly approved in dicta, which says that states can prohibit this type person, this type person, this type person, but they have given no indication that they would approve some sort of generalized litmus test as to who gets to engage in their Second Amendment rights.
And she makes a few other, she throws some other things in there with the kitchen sink. There's a Fifth Amendment argument regarding take-ins, 14th Amendment argument, and we don't need to address all of that here. But I think this is we've been saying it, shortly after the New York State Rifle and Pistol Association v. Bruen case decision came out, we correctly identified this strategy for anti-gunners. Because what that standard is saying is, hey, look, if this is protected by the Second Amendment, it is presumptively unconstitutional. And then the burden is 100% on the government to explain why, based on the text of the Second Amendment, as informed by history and tradition, that this is something that would have been properly or legitimately regulated at the time of the adoption of the Second Amendment, 1791. Now, gun grabbers trying to elude this, and this is what we pointed out, is that they're just going to say this is not protected by the Second Amendment, and we're going to sidestep this entire issue. That appears to be what has happened here.
Yeah, and this will go before the Ninth Circuit Court of Appeals, along with the Washington law that was recently held to be constitutional, along with the California laws that everybody's been waiting for the district court to rule on down there. And so the Ninth Circuit is definitely going to have its plate full with various Second Amendment challenges. And so it'll be interesting to see how they approach it, and then ultimately these cases will be heard by the Supreme Court.
Yeah, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm. It's been brutal lately by sharing this video. We'd also like to answer any questions you have in the comment section down below, so make sure to post those. And until next time, we're the Armed Attorneys.